Good morning, everyone, and welcome to this employment law webinar hosted jointly by Tilleke Gibbins and the Australian Chambers of Commerce in Cambodia, Laos and Myanmar as part of the ongoing AustCham legal webinar series. As the region has begun to emerge from the worst of the COVID-19 crisis, understanding the ins and outs of employment law across the region has really never been more important. And our speakers today will be covering the essentials of current labour practices and the core legal obligations in each jurisdiction, as well as addressing some of the more specific issues pertaining to COVID-19, as well as jurisdictional issues, and the impact that they have and will continue to have on employment, including things like vaccine mandates, restrictions on travel, import of foreign labour, and similar complicated matters. Hopefully making them nice and simple and practical for you to implement on your side. Before I introduce the first of our speakers, I just have a few small housekeeping points. Firstly, we're very pleased to welcome your questions as they may arise during the session, and we invite you to write them into the Q&A box at the bottom. Just to note that we do have a very high number of registrations for today. So all attendees have been placed on mute for the time being, and we'll be addressing all of those questions during a Q&A session at the end of the webinar. So please do write those questions into the Q&A box at the bottom as you have them, and we'll address them all together at the end. Similarly, if you have any issues with the software, I think after 18 months, we're all getting fairly comfortable with Zoom by now, but if anything does break or you have any technical issues, please do type those into the chat box and our IT team will be on hand to assist and will reply and get that sorted as quickly as we can. Secondly, the presentations from today's session will be made available to all attendees. You'll receive an email from us shortly after the session that will ask you to complete a short feedback survey, and on completion of that survey, you'll receive a link to download those files. Even if you don't want the files for any reason, we do encourage you to complete that feedback form, please. It's really important to us, and it helps us and helps the Australian Chambers to make sure that we are really delivering the best value possible to you with these webinars and with these updates. So yeah, you'll receive that shortly afterwards. Okay, with the housekeeping out of the way, I would like to move on quickly to our first speakers of the day. We will be starting in Cambodia. So I'd like to introduce you to Jay Cohen and Sokan Malispuang Wanawut. Jay is a partner at Tilleke Gibbins and is director of the firm's operations in Cambodia, based in our Phnom Penh office. He's a highly regarded and trusted advisor to many of the world's largest companies on their commercial operations in the jurisdiction, and has been helping some of the largest companies in the world and some of the largest regional companies with their labor and employment matters in Cambodia, both before and during this COVID-19 situation. He's ranked as a leading lawyer in Cambodia by many of the world's leading publications, including Asia Law Leading Lawyers, Chambers Asia Pacific, and the Legal 500. He's joined today by Sokan Malispuang Wanawut. She is an associate in our Phnom Penh office who works very closely with Jay on labour and employment matters, and she's particularly sought after for the clarity, commerciality, and practical relevance of her advice. In addition to her exceptional reputation in legal practice, Pung also has a very intimidating academic background, holding a degree in law from RULE, that's the Royal University of Law and Economics, a BA in English from the University of Cambodia, and master's degrees from Ateneo de Manila University in the Philippines, and another master's degree in the law and settlement of disputes from the United Nations mandated University for Peace in Costa Rica. A very impressive set of credentials there, and I'm sure you'll agree, far more qualified to take this webinar forward than I am. So on that basis, I will hand over now to Jay and Phuong from our Phnom Penh office.
Great, Zach, thank you very much for that introduction. Everyone, I'm really excited to talk to you today about Cambodian labor law and also talk about some of the COVID implications and how that relates to the Cambodian labor law as well. So today you can see the topics that we're going to be discussing. So we're going to go through each one of those today. I'll be taking the first three topics. My colleague Phuong will be handling the last two topics. So at the very beginning, we just want to highlight one simple point regarding like the minimum wage. So often this is a popular question. So for 2021, for the garment, textile, and footwear industries, the minimum wage is $192 per month. Just to be clear, there are no other minimum wages in effect for any other industries at this time. So this only applies to the garment sector. If the employee is on probation, then as we mentioned, the minimum wage is only $187 per month. And we'll talk about probationary periods a little bit later in the presentation. So at the very beginning, I'd really like to talk about what kind of employment contracts exist under Cambodian law. And it's important to understand this because it also impacts your ability to terminate people, and it also impacts severance. And those are both topics we'll discuss a little bit later today. So for the form of employment contracts, you have two. You have fixed duration contracts and undetermined duration contracts. A fixed duration contract, as the name suggests, is a contract with a fixed term, and it's in writing. And the total duration of a fixed term contract cannot exceed 4 years. So one of the new regulations that came out in the last year or so had to do with how do you calculate the maximum term of a fixed term contract. And this is important because many employers like to have employees on fixed term contracts. So the rules are relatively simple. For the initial term of a fixed term contract, the maximum initial term can be up to 2 years. It can be less, you can make it 6 months, you can make it 1 year, but the maximum initial term of a fixed term contract is 2 years. Then you're allowed subsequent renewals for an additional 2 years. And these subsequent renewals could be, you could have 6 months, 6 months, 6 months, 6 months, up to 2 years. So the total maximum duration is the initial term plus up to 2 years of renewals. So the total maximum duration could be 4 years, but it could be less. If your first initial term is only 1 year, and then you have 2 years of renewals, then the total term would only be 3 years, 1 year plus 2 years. So if you want to have a total duration of 4 years, you have to have an initial term of 2 years, and then you can have subsequent renewals for an additional 2 years. After that 4-year period, then the contract will be considered an undetermined duration contract. Or if you want to have another fixed term contract, then the employee has to have a break, no employment for 1 month. If there's a break in employment for 1 month, then you would be allowed to hire an employee again on a fixed term basis. And again, these are just some examples that make it clear how you calculate the initial term and the renewal term. So we just talked about this. So this slide is something you can refer to if you want to request a copy of the presentation. So you've now made a decision. What kind of contract do you want? Do you want to give a fixed term contract, an undetermined duration contract? The next question that many people often ask when they're structuring their employment relationships is, can I have a probationary employee period for my employees? And the answer is yes, probationary periods are allowed. For regular employees, it's a 3-month probationary period. And then you have for non-specialized employees and specialized employees, a reduced probationary period. So regular employees are typically office workers. Non-specialized employees tend to be unskilled laborers, and specialized employees tend to be skilled laborers. There aren't very clear definitions under Cambodian law, but that's how they're generally understood. So if you have general office workers, retail workers, then you can have a 3-month probationary period. And it's important to note that the probationary period cannot be renewed. You get 1 probationary period and that's it. You can't say, well, the employee, they weren't that satisfactory at the end of the probationary period. Let's do another one. You only get 1. During the probationary period, if you do decide to terminate the employee, then no notice is required. Another popular topic for employers is you've chosen your employment contract, you've set a probationary period, but then a lot of employers have questions about what are the working hours and what are the overtime payments in Cambodia. So in Cambodia, the working hours are 8 hours per day or 48 hours per week. So you can, under Cambodian law, require people to work 6 days a week. That'd be Monday to Saturday, typically, for 48 hours. For the overtime rates, it a little bit depends on when people are doing work. So if people are working in the evenings, that's 130%. A regular standard overtime rate is 150%. And if you're having them work on public holidays, then it's 200% of the normal rate. So those are the overtime rates. Now, under Cambodian law, overtime applies to all employees. Technically, it applies to the CEO, and it also applies to a standard office worker or a factory worker. In practice, many white-collar employees do not get overtime, but there is no basis in law for that. I mean, technically, everybody's entitled to overtime. Also, for the amount of overtime, it is limited to 2 hours per day. And you're not allowed to have employees work more than 2 hours a day. Although in some industries, like legal services, it might be common to work more than 2 hours a day. In terms of what sort of like benefits in terms of annual leave you get, Cambodia is quite generous to employees, and there's a variety of leave that's available for employees. So first off, employees are entitled to at least a weekly day off. And as mentioned, employers can require employees to work 48 hours a week, so that's 6 days a week. So that means you get at least 1 day off. Now, many employers, of course, give their employees 2 days off, but you have to give them at least 1 day off. Then employees are entitled to annual leave. So under Cambodian law, it does say that they're entitled to 18 days per year, which is 1.5 days per month. Now that assumes that they work a 48-hour work week. There are some other arbitration council awards and some other documents that suggest that if the employers only work 5 days a week, if they only work a 40-hour work week, then the amount of annual leave could be prorated. So in that case, if it's prorated, then the employers would only be getting 15 days per year or 1.25 days per month. To be honest, it's not that common to see the annual leave prorated in cases where employees are only working 40 hours a week, but that could be supported under Cambodian law. In terms of public holidays in Cambodia, employees are entitled to 22 days per year, and the Ministry of Labor issues a regulation every year that sets out the annual leave. So I think it's also good to be aware of like when those days of annual leave are, because that could also trigger overtime if employees are required to work on those days, and that might particularly affect employers in the retail sector where malls, restaurants, hotels will be open during public holidays. Then employers are also entitled to something called special leave. So special leave is for 7 days per year. This special leave is meant for family matters, wedding, if certain family members are sick, if certain family members pass away. Employers can require employees to deduct it from their annual leave if they have annual leave. However, if the employee has used all their annual leave, then they're still entitled to take their special leave. And there are certain mechanisms under Cambodian law where the employer can require the employee to make up that special leave by working overtime without pay to make up for the special leave that they've taken. So that's something to maybe consider if the employee has already used all their annual leave and then needs additional special leave as well. Lastly, when we look at like the leave scheme, I want to talk about maternity leave. So Cambodia has a generous maternity leave policy. All women are entitled to 90 days of maternity leave per year. And if they've worked for at least 1 year, then during that time, they're entitled to half of their wage. So basically, they're entitled to 50% of their wage during the maternity leave if they've worked for at least 1 year. If they have not worked for at least 1 year, then the maternity leave would be unpaid. They're still entitled to the maternity leave, but then the employer is not required to pay for that. In terms of sick leave, Cambodian law is very ambiguous in terms of like what kind of sick leave an employer has to give an employee. Typically, most employers will state in their employment contracts that employees are entitled to a certain number of days of sick leave. 7 days or 14 days is quite common. However, under template internal rules prepared by the Ministry of Labor, and internal rules are something that are applicable if an employer has more than 8 employees, it suggests that the employer is obliged to pay an employee's salary 100% if an employee is sick for 1 month. If the employee is sick between second and third, 2 to 3 months, then the employer has to pay 60% of the employee's salary. And then from the 4th month and longer, the employer no longer has to pay the employee's salary. So potentially under Cambodian law, employers have a significant obligation to pay employees during sick leave, certainly for the first month, and then for the 2nd and 3rd months, a partial payment as well. From a practical standpoint, we recommend that employers do set a certain number of sick days in an employment agreement. Again, typically 7 or 14 days, just to set some sort of expectations. And then if employees are sick and they need additional time, then they would still be entitled to receive payment. Another topic we'd like to address in terms of benefits for employees is something called seniority payments. So seniority of payments applies for employees that have an undetermined duration contract. So if your employees have a fixed term contract, then they're not entitled to seniority payments. If they have an undetermined duration contract, they are entitled to seniority payments. And for many of you that are familiar with Cambodian law, it replaced something called indemnity for dismissal. So previously under Cambodian law, if an employer terminated an employee, employees were entitled to a certain payment based on length of service. However, under this new regulatory scheme, employees are entitled to something called a seniority payment, which is an ongoing payment equal to 7.5 days of average daily salary per 6 months. So over the course of a year, they would get 15 days of seniority payments, divided into 2 payments of 7.5 days at the end of July and the end of December. Just to let everybody know, currently because of COVID, the Cambodian government has suspended the obligation to pay seniority payments. So currently there's no obligation to pay them, but as COVID is now coming to an end and Cambodia is opening up, we can anticipate that the Ministry of Labor will clarify seniority payment obligations of employers shortly. So I think this is something to watch out for. I will say this is a bit more of a complicated topic, and this could be covered in depth. This could be covered in depth, but today I just wanted to highlight that there is this obligation to pay seniority payments, and employers should be aware of that. And they should keep that in mind if they are setting salaries for their employees. Quickly, we're going to talk a little bit about some of the tax and National Social Security Fund obligations of employers. So for taxes, Cambodia has a very simplified system where employers are obligated to withhold salary tax from employee salaries. So this slide describes the tax rates. They're progressive from 0 to 20%. So overall, Cambodia has very reasonable salary tax rates, and the employer just simply withholds them from the employee salary. And then the employee currently has no obligation to make any other filing. Employers should also be, in addition to salary taxes, employers should also be aware that employers also have obligations to make payments for Cambodia's National Social Security Fund. So under the National Social Security Fund, there are 3 components. So there's an occupational risk insurance scheme, a health insurance scheme, and a pension scheme. It's important to know that the pension scheme has not yet been implemented, but the regulatory framework exists for its implementation. So for the NSS coverage, the general rule is it covers all employees. So if you're a company and you have employees, they will be covered by the NSF scheme, and the employer will have to make payments. In terms of the employer's obligation, employers should note that they need to register within 30 days of opening the entity. And then they also have an obligation to notify the NSSF within 30 days of making certain changes of director, changing the entity's address, or closing the entity. So again, I think it's important for employers to note that once you've registered with the NSSF, there might be some ongoing obligations to notify the NSSF you make certain. In terms of when you have new employees, they need to be registered within 3 days of starting work. And then I think employers should just note that your obligation to make the NSSF contributions, it's due by the 15th of the following month. So these are the, I think, the deadlines to keep in mind. In terms of the amount of the contributions, for the occupational risk insurance, it's capped at 0.8% of the employee's average salary. For the health insurance scheme, it's 2.6% of the employee's average salary. And it's important to note that for both of these schemes, there's really a cap on the payments of US $10.20 per month. So even if you have like a high-level employee with a big salary, there is a cap on these payments at $10.20 per month. It's not so significant. And all of those for the occupational risk insurance and health insurance are borne by the employer. Now, for the pension scheme, it does talk about the regulation suggests it will be 4% of the employee's gross salary, and this amount will be split by the employer and the employee. However, we're still waiting on these implementing regulations. So it's a little bit unclear if this 4% is just the gross salary or if it will be capped in some way, as it is for the occupational risk insurance and health insurance scheme. I think this is a hot issue, and this is something that employers should be looking out for to see when the new pension scheme regulations are enacted and whether it actually gives some more clarity on whether there's any caps on the 4% payment, because that could actually be a very significant payment if it's not capped, particularly if your company hires like some senior employees. It can become a much more expensive obligation than the occupational risk insurance and the health insurance schemes. I do know there's some penalties if you make some late payments. They're up on the screen, so that's something you can look at if you request a presentation. Okay, now we're going to quickly review the issue of suspension, mass layoffs, termination, and severance. And this is actually a really interesting area because this is one of the areas most affected by COVID, suspending employees. So Cambodian law does allow for the suspension of employment. And I would just like to highlight two areas that allow for suspension. So one, the employer can suspend the contract if there's serious economic or material difficulty. And this could arise during COVID when business conditions were very weak. And the employer can also suspend employment contracts for reason of force majeure. And arguably a pandemic falls within the definition of force majeure. So if you are an employer and you are experiencing extreme economic distress because of COVID, there would be grounds for suspending employment contracts. If you do suspend employment contracts, the maximum duration is 2 months for serious economic reasons and 3 months for force majeure. There's also a procedure in place where you have to notify the Ministry of Labor and Vocational Training if you do decide to suspend employment contracts. Particularly in the garment sector, you saw a number of employers suspending employment contracts during COVID because a lot of orders were being canceled and a lot of these factors are becoming under a lot of pressure. If an employer does decide to engage in mass layoffs, it is just sort of important to note that there is a hierarchy in who gets laid off. That's set up on the screen. I won't talk that much about it, but just keep in mind, if you suspend employment contracts, you have to notify the Ministry of Labor. If you just do decide to do a mass layoff, there is a hierarchy of like who should be laid off first. If you do decide to terminate employees, and this also would apply to mass layoffs, there are certain notice periods that companies need to adhere by. So they're up here on the screen. So if you're a fixed term, you can see the notice that you have to give employees if you decide not to renew the contract. And then for undetermined duration contracts, you can see the notice periods that would apply. So I think it's actually a really important point to keep in mind, because if you don't give notice properly, then the employer will have an obligation to make a payment in lieu of notice. So if you're an employer and you want to minimize the amount of payments you have to make to an employee on termination, then it's very important to pay attention to these notice periods. So once you've decided to terminate an employee, another question is, what kind of payments would you be obliged to make? So for employees with a fixed term contract, an employer is obliged to make a payment of 5% of the total wages paid during the term of employment. If the employee has an undetermined duration contract, then there are no severance payments anymore that need to be made. There's no indemnity for dismissal. However, you would have to make any sort of seniority payments. You would be making seniority payments before you terminate the employee. And then for the final termination, you would be making a final seniority payment. And that would be it. If you terminate an employee, one of the hot questions is whether there's a need to pay damages. And the Cambodian labor law says if an employer does not have a valid reason, then it has to pay damages. And this is actually one of the areas where there was a big update during COVID. The government clarified that economic distress is a valid reason for terminating employees. So if companies are suffering from economic distress, a slowdown, and they do decide to terminate employees, that's considered a valid reason. So then there's no need to pay damage. This discusses a little bit like the amount of the damages. I'll just say there are different formulas for fixed term and under term duration contracts. And then the last topic I'll discuss is really like the termination package. So if employees have a fixed term contract, then this discusses what needs to be paid to them, their last salary, any compensation in lieu of remaining annual leave. So you have to pay out annual leave. And then this 5% severance payment that I just discussed, and then potentially damages. For persons with an under-term duration contract, there's a more complex termination severance package that needs to be paid. So that's also discussed on this slide. Basically, you have to pay last month's salary, compensation in lieu of notice, you have to pay out annual leave, and then a final seniority payment, potentially. So, and then potentially damages, depending on the reason for the termination. So this is a little bit more of a complicated formula, and many clients often will require assistance like calculating this termination severance package for employees. Lastly, when you terminate employees, you have to provide them with an employment certificate. What's required is set here on the slide. That's just a good thing to remember as well. When you're thinking about the process of terminating employees, you have to give them notice. You should prepare the severance termination package. At the very end, you should give them an employment certificate. So with that said, that brings me to the end of my portion. I'm going to turn over the presentation to my colleague, Huang.
So thank you, Chair, and good morning, everyone. So now I'm going to talk about the vaccine mandate and data privacy. So in response to the COVID-19 pandemic, business owners have been developing and implementing business plans to manage their way through the pandemic and beyond. And some employers are considering whether to mandate workers to get vaccinated against the coronavirus. Today, we will look at the legal risks and implications of such a mandate in Cambodia. So Cambodian law does not, Cambodian law does not expressly prohibit employer from requiring employee to be vaccinated. And there are also no law or regulations specific to be vaccinated due to health, religion, or other reason as well. The government, however, issued a sub-degree number 66 that require vaccination for public officer to undergo vaccination as determined by Ministry of Health. However, the Ministry of Health has not yet issued any regulating that mandating the employee of business in Cambodia to receive a COVID-19 vaccine or addressing the issue of vaccination. So due to the absent regulation from the Ministry of Health, the focus turned to the country constitution, which in Article 31 guarantee all citizens equal treatment under the law without regard to race, color, gender, language, birth origin, social status, and other status. Additionally, if you look at the Cambodian labor law, it prohibits discrimination in employment based on race, color, gender, religion, political opinion, ancestry, and union membership or activity. That said, the authority would likely decide on a case by the employer are reasonable for a specific job and whether they would constitute discrimination in employment. So from my earlier discussion, it seemed that requiring employee to be vaccinated would likely not expressly contravene the Constitution or the labor law. But it's a little bit unclear whether rejecting or terminating an employee who refuse to be vaccinated due to religion or other protected status would be deemed discrimination in employment under Cambodian law. Therefore, if an employer employment because the employee refused vaccination, it could be deemed to compensation for the termination. So with my explanation, the risk of company coronavirus is still low because it does not seem to expressly contravene Constitution and labor law. However, we do not deny the fact that the authorities still have discretion to decide on the interpretation of the term discrimination. So now let's move to another topic, which is the data protection. So data privacy questions are also being raised during this coronavirus pandemic, as employers are interested in keeping track of the vaccination status of their employee, and many have wondered if this information would constitute personal data under the various data protection law around the world. So Cambodia does not yet have comprehensive data protection legislation, but the most recent updates to the country data protection landscape was in the e-commerce law, which has a scope that is limited to virtual or digital data protection. So, and other data protection matters typically fall under the right to privacy, which is protected in broad terms under the Constitution, the Civil Code, and the Criminal Code. Now we highlight the definition of the personal data under Cambodian law. In fact, Cambodian law fails to define the term personal data. And if you look at e-commerce law, the e-commerce law has a broad definition of data. We possibly include any information of the employee. So due to the absence of the definition of personal data, it remains plausible that including information concerning the employee vaccination might be viewed as the personal data of the employee. And if you look at the Cambodian e-commerce law, and there is a provision that states that anyone who stores private information in an e-commerce context must use all means to ensure that such information is safely protected. E-commerce company would be protect employee privacy right during the storage and processing of their personal information, and also include in addition to the e-commerce law, Cambodian citizens also have broad data privacy rights under Cambodian law of general application, which personal data can only be collected, used, or disclosed by obtaining consent from the employee regarding how the data will be used. So in the meantime, we would recommend obtaining the express consent of employee to record or obtain vaccination status information of the employee. Now I will move to part 5 of the presentation that I will talk about work permit, visa, and entry requirement. So first thing is about the registration requirement, which is the first step. The employer must register a company with the MLVT that include the declaration of the opening of the enterprise or the company. And they also need to register the number of initial employee in the form of declaration. And there is something that is called payroll book via computer system. So if you make payment to the employee through the computer system, if the company have the employee that exceeds HP, the internal regulation also required. For step 2, employer must apply at the MLVT for the employment book for each Cambodian employee, and in the employment book, it will be issued once at the commencement of employment, and the validity would be permanent, so you don't need to renew it. And when at the end of employment, or if the relationship with the employee, for stationer must justify Cambodia legally, they need to have a valid visa. For work permit, there are two steps in order to apply for work permit. The first step is to apply for quota, and it cannot be exceed 10% of the total number of the employee. And when the quota is approved, enterprise must apply for work permit for each foreign employee. For this topic visa extension, I will not go into very detail, but what to remember is that there are many documents that are required for the foreigner to end their visa, such as the labor register document and some other document like work application form or residency letter. And this is the last part of my presentation.
Thank you again to Puang and to Jay for that great session on Cambodia. We'll be moving on to Laos next, which will be addressed by Dino Santaniello. I think many of you on this call will already be familiar with Dino from some of our previous presentations. But just as a reminder, Dino is the head of Tilleke Gibbins office in Vientiane. And he has very broad experience across many fields of law, but particularly labour and employment, as well as privacy and data protection, corporate establishment, and major commercial transactions, all of which, of course, have major labour and employment elements in and of themselves. Dino is a trusted advisor to both domestic and international companies on legal matters in Laos, as well as the cross-border elements of doing business in Laos and Thailand and other neighbouring jurisdictions. And based on the strength of his work in those areas and with those clients, he's been recognised as a leading lawyer by international directories such as Asia Law, Chambers Asia Pacific, IFLR, and the Legal 500. Prior to joining Tilleke, Dino gained extensive experience in-house in both insurance and oil and gas industries, and he brings that practicality to his advice, as I'm sure you'll see in the presentation today. He also, as I mentioned previously on imposing academic backgrounds, Dino has also spent a lot of time studying foreign languages to better help clients in these jurisdictions, and is fluent in French, English, Lao, and Thai, as well as conversant in Korean, although I'm assured he will be presenting today in English to avoid confusing any particular section of the attendees. So Dino, over to you in English, please.
Thank you very much, Zach. I confirm I will be speaking in English today. Don't test my Korean. It's been a long time, actually. I used to study in Seoul University, Yonsei University a little bit, and it was a good pleasure to be there, but so long time ago. Anyway, right now, so as my colleagues from Cambodia, I will be speaking about employment law in Laos. And just a little bit of introduction again. I've been living now in Laos for about 5 years. About the same time, I'm also the head of the office of Tilleke Gibbins in Laos. And I'm actually in Laos, so I'm permanently based in Laos 24/7. So without further ado, we can start the presentation. Yes. So the agenda actually is not different from my colleagues from Cambodia. So part one, we will be speaking about employment contracts and employment rights. Part two, taxes and National Social Security Fund contribution. Part three, termination, but also we'll be broaching on suspension of employment contract, as well as mass layoff, as it can be understood under Lao law. Part four, vaccine mandates and data protection, data privacy. And part five, work permits and visas. So as you know, the webinar is supposed to be rather brief, so I will not go in details, I will try to be concise, brief. If you have any question, I will be very happy to answer these questions at the very end of the webinar. Otherwise, anyway, if we don't have enough time for that, I'm happy to take any question offline by emails later on. So moving forward, part one, employment contracts and employment rights. So just here are the main type of employment contract and the law in terms of duration. So basically the two main employment contracts we have are fixed terms and the indefinite term contract. The fixed term contract is actually a contract that would be less than 3 years, while the indefinite term will be for contract which are exceeding that period of time. For fixed term contract, whenever we talk about 3 years duration, 3 years period for the term of the contract, it also includes actually the extension of the employment contract every time. Unlike Cambodia, there is no clear indication as to whether a 1 month break would be enough to start under a new fixed term contract or not, or it would be not enough and maybe subject then to interpretation as to whether or not the extended contract may be actually an indefinite term contract later on. But these are the rules. And actually, fixed term contracts are pretty useful because, as we will see in the Lao law, the probation period is pretty short. So that can be actually a good tool for employer to try out their employee for a longer period of time. On the right side of the screen, I try to give some kind of a very brief example as to what may be a fixed term contract and when that fixed term contract actually may be converted into indefinite term contract. So the implication actually to have to be converted into indefinite term contract may be a lot, especially in terms of severance payment, for instance. By law, there is no severance payment that is due to an employee whose fixed term contracts ends. However, if an employer wants to terminate an employee who has actually an indefinite term contract under Lao law, most likely, and then we'll see that in more details a little bit later, but most likely there will be severance payment that must be paid accordingly. Now, for the content of an employment contract. So actually, the law on labor provides some mandatory content to an employment contract. However, it's pretty unclear what may be the sanctions, actually, if some of the content is missing. I understand that it should be based on the case-by-case basis, and accordingly, the judge may, or the law authorities may consider how actually the lack of information of mandatory content may impact the employee, and if it could pose any damages to the said employee. But as you can see, the mandatory content is pretty basic. So here what is required is actually the full name and address of the employee and employee, scope of work, right, obligations of both the employee and the employer, salary, method of payment, duration of the contract, probation time, welfare benefit, working days, benefits, and so on. Now, speaking about the probation periods actually and the Lao law. So we have two types of probation periods. So first one is regarding those workers or employees which are considered as not having specific expertise, at least at the time of their employment. I mean, there is no specific expertise that may be requested for the job they have to do. So here the probation period is 30 days. On the contrary, for employees or labor with specific expertise, the probationary period will be 60 days. And it's pretty unclear actually what may be an employee without specific expertise or an employee with a specific expertise. I think we can just take into account the position of the said employee, for instance, or the degree that is required in order to fulfill the position and so on. And accordingly, you may have, as an employer, you may have actually to provide a 30 days or 60 days probationary period. The salary during the probationary period should not be less, cannot actually be less than 90% of the regular salary. And yes, there is an advance notice to be provided whenever the employer wants to terminate an employee under a probationary period. Very important thing to note is that the probation period cannot be extended. regardless of the position of the employee, for instance. So this is why I referred earlier for a fixed term contract. It can prove useful actually to be able to test an employee for a longer period of time that is provided under the law for the probationary period. But at the same time, be careful whenever you use a fixed term contract, because qualified people in Laos is pretty scarce to date. So you may not want to, you may want to secure that employee as soon as possible. So in any case, probationary period is pretty short. So, and you cannot extend it. So you may think about the possibility of a fixed term contract. Also, 7 days before the end of the probationary period, it would be required that you inform the employee whether or not the contract will be confirmed. And also be minded that if no probation period is provided under the employment agreement, under the employment contract, then it will be deemed that there is no probation period and the contract will just start as is. About the leaves. So these are the leaves as provided under the law on labor. And you can see there is some flexibility, for instance, for the employer about the weekly day off. So the law provides that it's 1 day per week. So usually it would be Sunday, but it really depends on the agreement based on the employer and the employee, or 4 days a month. So again, it depends what the employer and the employee may agree on. Annual leave would be 15 days per year, but 18 days for those working in a sector that may be deemed dangerous, for instance, working maybe in position factories, which require to use a lot of physical force, or maybe dangerous for the health, generally speaking. Public holiday here, 8 days per week. So Laos is pretty cheap actually as compared to maybe Cambodia and Myanmar in terms of public holidays. But this does not include all the religious day or traditional holidays that may be granted also by the employer. And I have to say in Laos, we have a lot of religious days or festival where usually Lao people or even then the people residing in Laos will not be expected to work. But again, it has to be very clearly stated between the employer and the employee. What we would recommend usually is that at the beginning of every year, you inform, the employee inform clearly to the employees the public holiday that would be allowed to the rest of the employees, just to be sure that there is no misunderstanding. Also, it's fun fact is that foreign nationals also entitled to take a day based on their national public holiday. So here I just read the example for US citizen. In Laos, they are entitled to actually ask for having a day off on the 4th of July. Will be the same for French people on the 14th of July. Personal leave, we'll see that very shortly. Maternity leave, at least 105 days, and 42 days must be taken after giving birth. And for the sick leave, it's 30 days per year, full pay. And for the sick leave, it's also a requirement that the medical certificate should be also evidenced at the time of the sick leave requested by the employee. Personal leave. So this is a little bit like Cambodia, I guess. It's based on personal matter, and these matter are, here is the exhaustive list. So whenever the employee's fathers, mothers, husband, or wife, or children are injured and hospitalized, here it's very important to note that the law really provides hospitalized. So it should be, and according to a literal translation, it would be, it is said, sleeping at the hospital. So if a children, a mother of someone is just feeling not good, staying home, by law, strictly speaking, it should not fall into a personal leave. Then also in case of passing away of the father, mother, husband, or wife, or children of the employee, whenever there is a marriage, when the employee's wife also gives birth, so that's a good thing. Daddy in Laos are also entitled to take a parental leave. And whenever the employee is also affected by natural disasters. One thing also to note, which is very important, is that the law on labor provides that not less than 3 days must be granted, which means that whenever an employee takes a personal leave, the employee is entitled to 3 days. and the employer cannot ask the employee to come back to the office earlier than that. Minimum salary, 1,100,000 kip, so about $105 or so, but it's actually under debate given the situation with the COVID-19. There was a lot of inflation in Laos. Prices for common goods actually have actually increased a lot, and there are some talk to date, even among the government, to consider increasing the minimum salary. We're not sure how much, and it's not supposed to happen before 2022 if it will happen. But most likely we will hear about some news on that earlier next year, I guess. Working hours and overtime. So I will be brief on that. Here is all the information. So working hours is limited to 8 hours a day, or 48 hours per week. And beyond that, there will be approval required from the workers' representative or the majority of the employee, plus an advance notice and an explanation from the employer. The overtime rates will also differ depending on whether the overtime is actually performed during daytime, nighttime, but also if the overtime work is also performed during public holidays or not. Lastly, I just wanted to provide a little bit of clarification about what may be considered an employee or an independent contractor in Laos, because we have that question quite a lot actually from our clients. So I thought it was a good opportunity to try to clarify on this. First of all, the Lao law does not provide any definition about who is an independent contractor according to Lao law, but we do have some other clues from definition from employee and employment contract, and also service contract, which speak about service provider, hence independent contractor. So what is very important to take into account, and what will very differentiate employee from independent contractor, and it is actually written under the definition of employee in the Law on Labor Article 3, we have to take into account whether or not there is a supervision by the employer to the employee. That is, I think, the most important part. And then, of course, the salary, the wage. So the employee would be paid on a regular basis, whether or not the work will be performed. Please note also as well that there is no possibility in Laos to sanction an employee economically for, I would say, a bad performance of work, which may be the case actually for independent contractor. And also whether or not the employee has benefit. So this will be, when I talk about benefits, sorry, it will be National Social Security Fund, for instance, or welfare like that. So this will be the main differences between what is an employee and independent contractor, and how an independent contractor may be actually interpreted as an employee by the local authority. For me, the most important one would be the supervision. So we may be talking about working hours, all those management, performance review that we may have as an employee towards the employer. Salary, taxes, and social security contributions. I will be quite brief on that. So Laos actually applies the progressive rate on the salaries. So as you can see, the tax will be applied according to a certain tax bracket. And this is how Laos calculate and levy salary tax on the employee. It's pretty much the same as we can see that in many other countries. So it's not something very particular to Laos. And about the contribution to the National Social Security Fund. So this is a very important point, and recently the Lao authorities have tried to be more strict on the implementation of the contribution to the National Social Security Fund. First of all, that contribution concerns all businesses having one or more employees. So here there is no limitation about the employee. And at the time of to date, at the time of the creation of a legal entity, of the incorporation of the legal entity, it is required also as well to go and register with the National Social Security Fund. So whether or not the employee is a foreigner or Lao national, it doesn't matter. everybody must contribute to it. So the percentage rate for the contribution from the employee's side is 6% of the employee's salary, and the employee's contribution amounts to 5.5% of the employee's salary. But as you can see below, there is actually a cap on that salary, which is 4,500,000 Lao Kip. So about 400, maybe $60 or so. I mean, I have to say the rates, the exchange rates change pretty fast nowadays. So here we gave also some more clarification about what the real contribution may be at most. Termination. So I will talk about first about suspension of employment contract, because it was indeed something very important. I mean, a question that we had a lot during that pandemic period, and we still have, unfortunately. So under Lao law, there are very few opportunities to be able to suspend the employment contract, and this does not really much concern for economic reason, save for an exemption I will talk about very briefly. But mostly suspension of an employment contract will be okay for national service purpose, or if the employee is detained in certain areas, and that's it. Now, let's say one employer has to suspend the activity because it's not viable anymore. There is no customers due to the pandemic, and we've seen that a lot in the hospitality sector, for instance. And here, so the employer can suspend the activity or even stop the activity entirely based on the decision of himself or herself, I mean the employer. But anyway, the employer will have to pay an allowance, which is at least 50% of the salary of the employee. So this will not be possible based on the fact that the employer has to suspend the activity or stop the production. The employee is not entitled to actually stop paying their employees also as well. One solution that may be found is through a mutual agreement. But again, I think the employer should be very careful and that this mutual agreement may not be considered as an abuse of power, for instance, from the employer. And there may be very valid, good reason, and be sure that the consent of the employee was informed. So termination of employment contract, in the Lao law, each party can terminate the contract whenever they want, almost. And there is an advance notice for that. So whenever the termination comes from the employee or the employer, there is an advance notice, which period will depend on the qualification of the employee. Again, we see those employees without specific expertise and those employees with specific expertise. So basically, the advance notice will be 30 days advance notice will be required for employees without specific expertise, and 45 days for employees with specific expertise. What may be possible, though, is that both parties agree that the advance notice may be provided, but the employee is not does not have to come to work. So in that case, then the advance notice of 40 days may be just in practice, maybe just not a fact. I mean, the employee will not have to come to work, and the termination may be made faster. Also, there is a possibility to proceed with a mutual consent separation based on mutual consent from both parties. So usually, whenever the termination will be made by the employer or the employee, then comes the question about the severance payment. So termination by employee is possible, and the severance payment would be due also as well if the employee does leave the work for health issue, or if no resolution of issues raised by the employee was not solved by the employer. And those issues must be important issues that actually preclude the employee to work in the company. Whenever also there is a relocation of the working place, and the trade union, the majority of the worker, or the employee's representative have agreed that the relocation preclude the employee from working normally, in addition to that, approval that the relocation is a problem to the employee to continue to work must be signed also by what we call the village chief. So the village chief will be the one person from the authority who is administrating a administrative zone where the working site is actually located. And indeed, there is also express mention about harassment. So if an employee terminates an employment contract according to harassment, then the employee will also be granted with severance payment. For employer, termination without fault of the employee is subject to severance payment. Lack of skills, health issues, business reasons, we'll see that very, very shortly. Those are actually reasons where the severance payment must be paid. For your information, whenever it's because of lack of skills or health issue, the employer must also try the employee in another position that may be more suitable to the employee first before terminating the contract. And finally, mutual consent. If the mutual consent actually was at the initiative of the employer, then it may be, even though it's not written in the law actually, but according to our experience during this labor dispute, the authorities may require that the employer provide also a severance payment in this regard. For your information, severance payment is calculated as 10% of the last salary. And the last salary here will include all the allowances also as well, multiplied by the total month of worked by the employee in the company. So there is also some here reasons which are unjustified to terminate a contract. And as you can see, for instance, whenever the employment contract is terminated without sufficient reason, or when the employer abuses of its power, which actually makes the employee unable to undertake its work. And the same thing whenever the employee is pushed to resign because the employer did not try to amend the condition of the work employee despite several notices made by the employee accordingly. And in terms of unjustified termination, it's very important because here the severance payment will be calculated based on 15% of the last salary provided to the employee. And for your information, there is no ceiling here. So it could be kind of substantive. So here are all the cause for resignation without severance payment. I will try to be quick, otherwise I'm scared I will be not have enough time for the rest of the webinar. So please just have a look at it, and if you need some more clarification, do feel free to reach out to me in time. And also there is a list of protected employees whose contract can be terminated, but the trade union must give their consent for that. So termination for business reason, it's when, for instance, for pandemic purpose, pandemic reasons, sorry, the company or the employer has incurred very substantive loss, financial loss. And in this respect, it's possible for an employer to terminate the contract of the employees. However, severance payment would be due in this regard. So usually it would be in a three-step basis. So first of all, there would be a meeting with the trade union or the employee's representative or the majority of the employee. And the employer here will inform that the company will actually proceed with a kind of a mass layoff, actually. And then after that, the employee is entitled to serve the notice of 30 days to 45 days to the employee to terminate the contract. And once this is done, the employer must issue also a work certificate to each employee within 7 days. So here the law provides about 7 days, but actually this is something where there is no sanction according to the law if the certificate is not provided within the 7 days. So very briefly, vaccine mandates. So like Cambodia, Lao law does not prohibit employers from requiring employees to be vaccinated. However, there may be some issues. And the first one, I believe, would be the constitution actually of Laos, which provide that the rights of the Lao citizen over their bodies are inviolable. So accordingly, it may be difficult for an employer based on this to simply request an employee to force the employee to actually be inoculated with a vaccine. And why not maybe terminate the contract based on that basis if the employee refuses. And also the other thing is that the employers under Lao law and Lao labor law generally are prohibited from direct and indirect discrimination towards employees. So now the question would be to know as to whether or not requiring someone to be vaccinated would be a discrimination, so to speak. On the other hand, there are also some other law and regulation that mandates the employer to ensure a safety place for work. And accordingly, I think there is a contradiction according to the laws in Laos, and it's pretty unclear on how, if the case has to reach someday the Lao People's Court, for instance, how the judge may decide on that. What we would recommend, though, is that the employer may impose vaccination in the employment contract. That may be one way, but importantly, maybe in the internal regulation, because the internal regulations are actually reviewed and approved by the Ministry of Labor and Social Welfare. And accordingly, if the ministry is okay with that provision, at least the employer may rely on the approval of the authorities on that. For general data, there is actually the law on electronic data protection in Laos, which is not a personal data protection law per se, but depending on the nature of the data, it is important to note that the employer requires the consent of the employee before collecting the data from the employee. And here, as you can see, so general data would be the data where no consent is provided, is necessary actually, but then sensitive data are data talking about history of medical treatment. And here we believe that it may be also related to the COVID-19 period. In this regard, it is important to obtain the consent from the employee. And unfortunately, there is also a discrepancy with another type of data, which is prohibited data. And the law on electronic data protection provides that type of data, which also include health information. So we don't really know how is it different from history of medical treatment, but where health information is prohibited from being collected. Again, I don't think that, I think it's just a discrepancy, unfortunate discrepancy from the authorities. And at least the employer should be aware that the consent should be obtained from the employee whenever they want to collect some history of medical treatment or anything that is related to health. For your information, we have not heard of any sanction provided by the local authorities in regard to prohibited data so far. So beware whenever you collect data, it is very important that you ensure the following and also that the data will be very well protected. I will be very, very brief on the last part. For an employee, so for work visas and work permits, first of all, I would like to say that under Lao law, it is important to have a local employment contract. So we have a lot of questions from NGOs, organizations, which would like to rely on their employment contract entered into in the country of origin and come to Laos and ask for work permit accordingly. This is not possible. So basically, it is a requirement to have an employment contract with a locally established company in order to be able to work in Laos. For foreign employees, the condition to work, there are some conditions: no criminal records, be over 20 years of age, and receive a sponsorship from the company or individual in Laos. But actually, we are talking here about an employment contract. And also, we have to show that we have the relevant skills for the required position. This is the document that would be required actually to work in Laos. So the quota approval, which will be requested to the local authorities. If the local authorities approve the quota approval grant a quota approval to the locally established company, then they will issue what we call a authorization to import foreign labor. And this is where actually we can start the process to produce the work permit with the Ministry of Labor and Social Welfare. And once the work permit is obtained at the same time with the visa, it will be required also to obtain the state permit, which is the resident card if you want. So important to note also that for an employee employment contract is limited to 12 months, because every year we need to actually renew the work permit, the state permit, and the visa as well. So here is the kind of procedure that we'll have to repeat each year. Here are the sanctions whenever the immigration requirements are not duly fulfilled. I will not read them loud to you, but please have a look, and if there is anything unclear, don't hesitate to contact me accordingly. Eventually, I would like also to add that for now, Laos is still under COVID-19 restrictions, so international borders are still closed, save for a few flights, some weeks. However, the general rule is that it is not possible for a person to enter into Laos, and even to leave it, we need to have a special authorization. So to enter in the country today, if you want to enter into Laos, you will need to substantiate that you are working on a very important project for the country, or you have actually an employment contract with a locally established company. And a approval from the Ministry of Foreign Affairs Consular Department, along with the COVID-19 committee that was established now about 2 years ago, would be required if you want to enter into the country. I know that on my slides, I don't have any much more information on that, but I will make sure to put this information on the slide that will be shared with you. Again, thank you very much. I'm sorry if I was a little bit quick on some issues, but happy to take any question later on. Thank you very much.
Great, thank you very much, Dino. And yeah, I feel like there's so much content to discuss on this topic. I think there's always going to be a huge amount of questions around it. So with no further ado, I will move on to Myanmar. Today we are joined by Kun Yuadi. Yuadi Ternam is the director of Tilleke Gibbins' office in Myanmar, having moved over there in 2013. Following a decade in our headquarters in Bangkok as an attorney and a litigator. Since 2013, she very rapidly developed a reputation as one of Myanmar's leading lawyers, again recognized in international directories like IFLR, Asia Law, and various others. One in particular I'd highlight is in 2019, she was named to Asian Legal Business's top 40 under 40 list, as one of the brightest young stars in the jurisdiction. She advises clients on a full range of legal matters related to their business in Myanmar, and is particularly well known in the international business community for her level-headed and practical advice, which is particularly valuable in the context of the fast developing and sometimes unpredictable legal framework in Myanmar. Kun Yuadi is also a very enthusiastic promoter of cross-border business and investment into Myanmar, both in her role as Secretary General of the Thai Business Association of Myanmar, through her connections with chambers of commerce like the OSCHAM chambers that we are grateful for hosting today, and various others such as the World Bank and numerous other organizations. So a formidable thought leader, I'm sure you'll agree, and I will hand over to Kun Yuadi to take the reins on Myanmar.
Hi, hello everyone, and good morning. I think it's for me, I'm the last person to present on the Myanmar overview about the Myanmar law. I think it's in the past year, it is very interesting for Myanmar about the many changes and many things happen that may cause many issues for not only for the employer but also the employee as well. They have some, as you all may know, about the effect of the COVID pandemic and some the political situation in Myanmar. However, the law and regulation in Myanmar is not changed during this period, but still have some period or some relaxation for the employers about some payment of the social security or some getting back some money of the social security fund to the employee in the last year. But however, for this year, we need to see the situation again, and also they have some new law that issue in Myanmar, especially the taxation for the employees who need to pay for the personal income tax in Myanmar also need to be considered about the law that have some update under the Union Tax Law 2021 21 as well. Okay, for my topic today, we'll discuss about the employment contract in Myanmar, about entitlement of employee in Myanmar, minimum wage and overtime. They have some change and update for the overtime for the company that already get the Myanmar Investment Commission permit, that they extend the overtime for the employee to get more time, but whatever they still get double payment for their overtime. That may support the industry, the main industry in Myanmar. And another one that I already mentioned is about taxation of the employment income to the employee, and also the termination of the employment contract in Myanmar that are privacy immigration, and also the vaccination and visa entry during the COVID-19. I would like to focus about this because during this period, I understand that most of some expats already go back to your country, but this time, I think for the situation, some company may consider that whether when they can or when they should go back to Myanmar to work as before the issue in Myanmar, when and what is the requirement. Today I will inform you. Okay, let's start from our presentation today. As many of you who have already be the business or now start to consider to go and invest in Myanmar, when you have the employee, at least about 5 employees, you need to or much sign the employment contract, which is the mandatory contract that you need to use, that issued by the labor department. This contract is a template contract. You cannot you cannot to amend or change any part, but you made some request to have some additional clause that relate with about some rule and regulation that should be attached. However, it depends the additional rule regulation that you want to add based on your company policy or the international practice or standard. It will depend on the labor township officer whether they will accept to attach at the employment contract, or you need to use an issue announced by internal and cannot attach with the employment contract. This is depend on the labor officer at respective township that your office had the locations. And another issue that I would like to note is about the standard templates of the contract in Myanmar, mostly based on the current practice that don't have any an official announcement, that would require the fixed term contract at least 2 years and can be renewals. This contract also not mentioned or mandatory for the probation period, but the important date for your employee need to be mentioned is about appointment date. Is this mean that the first date that you appoint this person to be the employee of your company in Myanmar? How we consider to submit or sign the contract? You need to submit and sign the contract within 30 days of the employment. Is mean when you appoint this employee to be your company employee, you need to sign the agreement within 30 days. this is the one that is required. If not, or you fail to not register, they may have the imprisonment up to 6 months or 5 or both. It depends on the consideration of the labor officer. However, based on the current situations, they have some relaxation that you need to discuss and with the both employee and labor officers to consider. Mostly now they would not have any intention to get any imprisonment or fine to your company if your company would like to have an intention to sign the contract as officially signed. The requirement of the employment contract, they require 3 copies. One is for employee, one is for employer, and another one keep at the township labor office. This one is the one of the requirement if you consider to make an employment contract in Myanmar. In another interesting about the employment status in Myanmar, because they don't have some definition on what is the employee, what is the permanent employee, what is the temporary employees. But for the labor township officer perspective, if you hire anyone more than 3 months, they may consider that person to be your employees if they have any issue that may rate from your employee and have any labor dispute. The labor officer will consider this person whether they are with type of the employment or with a position. But only one thing that the labor officer will consider is this person already worked with this existing employer more than 3 months or not. If yes, they may consider and get the benefit should be the same as your employees. This is the one that you may need to note and concern when you want to hire anyone as your temporary or some trainee or some temporary or any contract. Please note about these matters. And as Laos and Laos and Cambodia already mentioned about independent contracts. Actually, in Myanmar, don't have any specific define about independent contracts. However, they have some type of contract that not more than 12 months that may require as the independent contract. However, based on the tax issue, the tax issue will just consider that person received the income in Myanmar when they're resident as the resident person more than 183 days. That person need to pay the tax in Myanmar. That's why when you hire anyone and that one get the income in any kind of matters and sign in independent contract, that person should pay the tax. And the company may consider to deduct the withholding tax on behalf of this person as well. Okay, the entitlement of the employees. As normal in other countries, the general 8 hours is a day, is a working day for the employee that must to follow. However, they have also some separate working hour for specific type of business. For example, shop, company, trading center, service enterprise. Mostly they will allow about 8 hours a day or 48 hours a week. For the factory, they must not exceed 44 hours a week, and oil field and mine must not exceed 44 hours a week because depend on the type of the works, and because some of factory and oil field they may have some a bit different work than with the shop or the normal works of the company. as I already mentioned, it's about mandatory for overtime payment that must be paid, and I will inform you in another in the next presentations. Whatever in 8 hours, they need to have the rest period, at least 30 minutes after work at 5 hours. You will get some breaks or lunch time or any break, but whatever you need to provide at least 30 minutes after working at the 5 hours for your employees. About the holidays and time off, Myanmar have the minimum holiday entitlement based on the Myanmar Gazette. In each year, they will don't have any specifically how many days for holiday in each year, but it will depend on the announcement by the Gazette. We know that the specifically date or the ceremony that may get the holiday, but however, each year there maybe have some different because some connection with the weekend or some have the special announcement. As you may learn about this year, in July to August, based on the COVID pandemic in Myanmar, the Myanmar government already announced for the public holiday since the mid of July until the beginning of August. It means this is also considered as a public holiday based on the announcement of the government, and the employees subject to get the full pay for their salary or their income. However, at least 1 week they need to get 1 day for day off. This is the requirement under the law. For medical leave in Myanmar is about 30 days of paid leave. In Myanmar, we don't mention about not mention about the sick leave. They mention only the medical leave. It means that every leave that under the 6 or they need to get the medical leaves or get the medical certificate from the doctors. However, it depends on your company policy. If you would like to mention about sick leave and want to exempt some medical certificate only 1 or 2 days, because that more cost some complicate to the employee, you can allow, because that one is more benefit to the employee, but in the law is not mentioned about the sick leave, just only the medical leave entitlement. And medical cash benefit, if the employee already applied for Social Security, they can get the medical cash benefit if they already registered with the Social Security at least for 6 months. And also maternity leave in Myanmar also about in total 14 weeks. It means 6 weeks before and after 8 weeks. This is the one that Myanmar is already provide for the women who get the maternity leave. Not only the women, for the fathers, they also get the leave for paternity leave, 15 days to the fathers as well. And another one is about adoption leave. They also get, if you if any employees adopt the baby, they can get 8 weeks for the child that under 1 year old. Okay, let's discuss about the minimum wage. Minimum wage in Myanmar is about 4,800 kyat. It's about approximately 2.5 US dollar or 96 baht per 8 hours for working day that I already mentioned. And however, for if the employer consider to pay the bonus in the end of the year or in the mid-year, there is no mandatory require or no specific about the bonus. That's why it will be the considerations of the employers and also the business operation in Myanmar for the employer to consider to give the bonus to the employees. However, for the company that not comply with the minimum wage, they may get some 1 year imprisonment and maximum 500,000 charge or fine. That this one is or both, but I think it's this minimum wage is quite low in Myanmar. That's why I think it's we consider and that the employer should pay at this rate to convince and to support their employees in Myanmar. As I already mentioned about overtime pay, for the previous one, the law already provides a maximum per week. It means about 2 hours per day because they allow for 6 days for working as maximum. However, as I already mentioned, Myanmar Investment Commissions who got the permit, they can get the maximum 20 hours per week and maximum 3 hours per day and maximum for 5 hours for Saturday. This is the one that more periods for the company that already get the approval under the Myanmar investment law and get the permit from the Myanmar Investment Commission. However, the overtime payment need to pay at the double. For the social security, as we mentioned, is it the same minimum amount with the employment contract that at least 5 workers or more that the company need to apply for the social security under the social security law. This one is the employee and employers need to be submit within 30 days starting from the contract or starting from the first date that they get the contribution or receive the salary. This one may not be the criteria, but this is the one that the employer and employee must to follow. How about the contribution rate? The contribution rate will be the first one. The employer must withhold 2% of the employee of the total monthly wage or salary. For the side of the employers, must contribute 3% of the employee monthly wage or salary by the employers. However, in Myanmar, they have the cap amount. Maximum should be at only 15,000 Myanmar charge, that from 6,000 from the employee and 9,000 at the contribute from the employers. At the cap of the maximum salary, even that employee have the salary more than about 10 million charge a month or 1 million charge a month, the Social Security will calculate based on the maximum cap of salary at $300,000 300,000 charge. Sorry. As I already mentioned again, on the 17th September 2020, as a result of the COVID pandemic, the Social Security Board also announced the provision for the Family Assistance Fund in amounting 40% of the normal Social Security to give to the employee by applied and applications. I think it's this period already passed and most of some company that already apply may already get the money. 40% is they will calculate based on the 40% of the contribution at the maximum of the salary, 300,000 charge. Okay, for the taxation of the employment income. For the foreign national who non-resident, and they may not subject to pay the tax if they don't have or if they don't resident in Myanmar within 183 days. However, it's not only consider only the non-resident or resident, but it should consider where the income is from. In case the foreign national who receive the money or receive the salary from the employers who are in Myanmar or company that register in Myanmar, they need to pay the tax in Myanmar. However, the foreigner who are resident in Myanmar more than 183 days, worldwide income need to pay in Myanmar. That's why this is the one that's an issue that you as the employers and employer need to consider about 3 factors about the resident issue. One, the second one is the resident issue is you are resident or non-resident. The second one is how many days that you live and stay in Myanmar. The third one, where is the income from the outside country or from the employer who are in Myanmar. This you need to consider about 3 issues, and then we will provide the legal advice based on the 3 factors for your consideration. And another one is about Myanmar national working in abroad. For example, the seamen who are working in the sea. Normally, they don't need to pay like the progressive rate for the income in Myanmar because they work in the sea. However, they need to pay for the flat rate at 10% of the income that they receive from abroad. Okay, the taxation rates of the employment income. This rate is changed because upon the Union Tax Law 2021 that just issued by the existing government or state administration councils, the rank is changed, and it means if you have the more salary, you need to pay low. I mean, based on the rank, is different from the previous year. However, the employee who have allowed for the allowance can get the basic allowance is 1 million charge for the co-resident for the parent can be request, and also 1 million charge for the registered spouse, and 500,000 for the child. But the 3 allowance need and require the parent, spouse, and child that stay together with you in Myanmar or live with you in Myanmar. If your parents, in the case of a foreigner, if your parent, your spouse, and your child did not stay with you in Myanmar, you may not require this basic allowance from the tax officers. However, in this year, the National Unity Government also issued the income tax and union tax law as well. The rank is maybe different from the SAC, but you can see and follow in this presentation, and the allowance and basic allowance is seen different and getting more benefit for the basic allowance, but the rank is may different from the union tax law that issued by state administration councils. Okay, let's talk about determinations. Normally, in Myanmar, the termination of the employment contract can be considered by the employers. However, the employer must provide a reason or strong reason and give the notice at least 1 month. However, if some any situations, for example, any dismiss under the act of gross misconduct. This is the one that's some kind like the serious offense that caused from the employee to the employers. This one, the employer can consider to terminate without any requirement or any notice, and actually no need to pay the severance pay as well. It's something like very serious because this one. However, but based on the practice, the labor officer will, even that get the gross misconduct, the labor officer still required to pay for the severance rate pay based on the past working that they work for the employer. The other reason for the termination that may cause in Myanmar based on the current situation, the company winding up, and also the suspension of the company and the death of the employee. This one can make the reasons to advance notice of the termination to the employees. However, Myanmar Labor Authority accept no at-will termination. It means all the termination must provide the reason what and why you want to terminate that employee, and then send the report to the labor officers about the employee resign for their records. As I mentioned, you need to keep the employment contract with the labor office. That's why when you terminate the contract, this termination need to be recorded and keep with the labor office as well. This is the rate of the severance pay. In case you hire some employees, but less than 6 months, this 6 months no need to pay the severance pay. This is the one of my note. But if you hire the employee start from the last day of the 6 months until more than 25 years, this type of the employee is subject to pay the severance payment or get the severance pay based on the termination. Okay, in case of the dismissal, if they have some misconduct and some violation that you try to negotiate and discuss with the employees, based on the current practice and the announcement by the Labor Department, they need you to send the notice to the employee. The first one as a verbal warning for the first offense. The second one is warning by the letters. You need to issue the formal letters. The third one is about signing an acknowledgement on the wrongdoing. However, these three warnings need to be sent to these employees within 12 months. If not, you are not able to dismiss these employees and need to start another year with them because it's not complete all the 3-time warnings, as they have something like violate or misconduct or do something wrong based on the company rule and regulation. If they stop since the first verbal warning and then continue to work, you are unable to terminate without any reason, or you are unable to lay off them without any reason. You must to continue to hire, accepting that you can consider that this person, you have the strong reason to terminate them. The resignation by the employees, mostly we will consider like volunteer by the employees. there no have exactly regulation about how we can comply and whether we need to pay the severance pay for the resignation people or how we can deal for the employment contract, because employment contract is already fixed term. In this matter is depend and relate to the employee who send the intentions of their resignation to the employees. This employer need to send the notice to the employer at least 1 month, and no severance pay will be made for this issue in case the resignation. In the retirement, this one is mostly about the civil servant that have the fixed periods of 60 years old. And also the Myanmar aging law also mentioned elders, is mean the Myanmar citizen who have age over 60. However, in the Myanmar law, in Myanmar labor law, or even templates of the employment contract, did not mention about the retirement clause. That's why it means that if you want to get or you want to set that retirement clause, that person should be considered as or the same as, based on our discussion with the labor office as well, the termination, because the existing Myanmar law is not mentioned about the age of the retirement. That's why the severance rate need to be considered if you want to terminate that person based on their old age or based on the retirement. This one is the thing that we need to keep watch what is will be changed or not. And for the pensions in Myanmar, is not exactly mentioned for the pension after the retirement for the private sectors. That's why this is the one is depend on your company rule and regulation. If anything that more benefit to the employees, the labor officer will give you an accept for that matters. For the data privacy, Myanmar, the same as Cambodia and Laos, we don't have exactly law to mention about data privacy or data protections. However, for the Myanmar citizen, they also have about privacy security citizen, and also the constitution also give the right to the citizen to have to reserve and keep their confidential informations. This is the all law that relate about and mention about the some data privacy. When you want to or connect to any type of act that you will do in Myanmar, for example, electronic transaction law, if you do some kind of electronic transaction, for example, online transaction, e-commerce transaction, some kind like that. And also competition law is about the law that also mentioned about this issue. And also telecommunication law is mainly focused on the person or company that provide the telecom provider that need to keep all information of the customer. However, after the state of emergencies, there have some suspension of Section 8 of the law protections or protecting. After the state of emergency, there have some suspension of Section 8 of the law protecting privacy and security of citizens. It means that the government agency can now intercept any communicate and data from the communications service providers, and also have some amendment on electronic transaction law 2004. They have allowed for the government can access to the personal data in the name of the stabilities, tranquilities, and the the important one is about national security. That one is because during the sensitive period, that this law is also have some amendment for the government to accept. That's why if you have run the business in Myanmar, you need to try to avoid any the confidential issue that may relate about the political issue, because it will cause some authority can access in your data for the reason based on the reason of national security as well. Okay, for the last part for my side is about the vaccination and visa entry during the COVID-19. In Myanmar, as the same as Laos and Cambodia, they don't have any specific provision for the vaccination in Myanmar. They don't have mandatory or forced to the employer need to, or mandatory to, or forced to the employee or employer to get the vaccinations. And also they don't have any specific leave for the COVID. However, the employee can get the medical leave up to 30 days if they get any infections based on the COVID-19. Even they don't have the law or force or specific regulation on the vaccination. However, they have the law, the Prevention and Control Communicable Disease Law, and also the Amendment of Prevention Control of Communicable Disease Law in 2011 that may consider based on the national health and national protections of the people. They may able to issue some regulation for the futures to enforce or ask the employer and employee to comply to protect for the COVID-19 in the futures. For the visa entry during the COVID-19, in actually the Ministry of Immigration and Population already announced the website for the foreigners who want to come to Myanmar for as a tourist and business by applying by e-visa based on the website that I show in these presentations. That can apply starting from the November 1st, 2021. However, based on the COVID situation in Myanmar, they also still have some temporary suspensions from the Ministry of Health, and also the Department of Aviation not allow for international flight to come to Myanmar. That extend until the November 30th, 2021. It means that, and I also go to the websites that I mentioned, and they also report and inform that the temporary suspension is mean now until the 30th of November, the person who want to come to Myanmar, whether in the tourist or business, that still cannot apply for visa, especially the e-visa. However, they also have some exceptional case for the embassy or the person who must or need to come to Myanmar. You can get the special request by the Line Ministry in Myanmar and also submit it to the Myanmar embassy in your country for entering into the Myanmar as well. For the person who already get the vaccination, you need to quarantine in Myanmar at least 7 nights. But for the person who not get the vaccinations, you can get and you must the quarantine at the place that allowed by the Myanmar government at least 10 nights. This is the one based on the current regulation in Myanmar that I would like to share you now. Okay, this is for my side of the presentations. If you have any further questions, please feel free to ask and send an email, and also in the chat box, I will keep answer for you. Thank you very much.
Thank you very much, Kunyuadi. That was excellent, really, really clear and direct, which is a rarity sometimes with Myanmar law in general. So that's very much appreciated. Thank you. We are now well past the end of our time, so I would like to thank all of our speakers today. That's Jay Cohen and Sukan Malistuong in Cambodia, Dino Santaniello in Laos, and Yuri Termngam in Yangon. Thank you all very much.